Well, good morning, everybody. I see that it's 10 o'clock, so I will get this meeting going. And welcome everyone to the WCA County Redistricting webinar. During today's webinar, we will explore the statutory and judicial rules that are impacting redistricting and then also review the handbook that WCA released. I'm Marcy Rainbold with WCA. I will be just sort of hosting this and also fielding questions for our speaker today. And we have with us today Ben Conrad. Ben is an attorney with Von Briesen and Roper. Ben focuses his practice on working with government and quasi-government entities with their legal, legislative, and regulatory issues, particularly those confronting county and other local governments. And before I turn it over to Ben, just a few housekeeping items. One, if you do have a question, there's a couple of different choices. You can either type in your question using the chat or Q&A function at the bottom of your screen. Or if you are on the phone, actually, Anne-Marie, are you still on? If they're on calling in, they have to press star nine.
Yes.
Star 9. And then Anne-Marie will unmute your phone so that you can ask a question. And you can also, there's a raising your hand function as well that you can use to indicate that you have a question you would like to ask. We're going to try to hold off on questions until the end of Ben's presentation. So hopefully he'll cover everything and maybe we won't have any questions, but if you do have a question and I don't relay it to Ben right away, that is because we're just going to hold off until the end of the program. So with that, Ben, take it away.
Thanks, Marcy. I hope everyone's doing well. This is an issue that maybe isn't super pressing right now. Obviously, it doesn't really start gearing up until 2021, but as it's something that only happens every 10 years, a lot of people aren't super familiar with the redistricting process. So we wanted to give a brief overview today. As Marcy mentioned, the association has also released a much more detailed handbook to go along with this. So getting started, redistricting can feel kind of like putting a puzzle together. It's a little confusing of a process. It's interesting because it's a very technical process mandated by statute, but also there's some interesting legal issues that come into play as well. So we're going to go through all those today. Again, broad overview. The first kind of half of the presentation here is going to be walking through those mechanics laid out by statute, and then we'll talk about some of the more relevant legal issues that kind of come along with that, and how that all ties together. So as some of you may be familiar with, the process of reapportionment and redistricting are mandated by federal and state law. So reapportionment has to do with the allocation of political seats. So when we think of congressional seats within the states, that's reapportionment based on population changes. What we're talking about today is redistricting, which is the political boundaries for state legislative districts, county districts, all the way down to aldermanic districts, that sort of thing. So counties in Wisconsin are governed by Section 5910, and that lays out the process for redistricting every 10 years. Again, giving a brief overview of the process. It's a three-step process. So importantly, counties when redistricting always start with a clean slate. So basically wipe away all the boundaries from the previous plan and starting over. Though that doesn't mean there's complete discretion to do whatever the county wants. Obviously, there's these traditional concepts of redistricting, which includes elements such as compactness, contiguity, and substantial equivalence of population. The last one especially is important, and there is a lot of legal issues that and tests that come along with that we'll talk about later. So this three-step process importantly applies to all counties in the state except for Milwaukee and Menominee, which have slightly different procedures. So step one of this process is the adoption of a tentative county plan. So the tentative plan has to be adopted within 60 days after the results of the federal census are published and distributed. So to accomplish this, each county board needs to propose a tentative plan. So that's going to include having tentative lines drawn for each district and the number of districts in that and so forth. And then hold a public hearing on the plan and adopt the plan. So breaking that down, step 1A is rules for drawing the district. So each proposed supervisory district needs to consist of whole wards or municipalities, and that's done at the municipal level for the creation of wards, and we'll go into more detail on that as well. The county needs to be divided into a number of districts equal to the number of supervisors, so one supervisor, one district. And again, all districts must be substantially equal in population. Territory must also be contiguous, so what that means is every district needs to be wholly touching one district. It can't be separated by another district, so you can't have part of one district here and then another district in the middle and then the rest of district one over on the other side. It has to all be connected. And also census blocks may not be divided except for in a few circumstances having to do with municipal boundaries and a couple other things. So then step 1A continued is statutes require intergovernmental cooperation. So not only is it good practice to do this anyway, but it's actually required by statute. So county boards are actually required to solicit suggestions from their municipalities concerning the development of an appropriate plan. And the reason for this, just being good practice anyway, is that municipalities have to create their plan and, municipalities have to create their wards in conjunction with the county plan. So they kind of go together. Municipalities aren't entirely beholden by the county's tentative plan. But the process goes a lot more smoothly if everyone is sharing information early and working together on this. So then step 1B is, as I mentioned, holding a public hearing. Gives the public an opportunity to comment on the plan and have some input. And then going along with that, step 1C is the adoption of the tentative plan. Again, based on public comment at the hearing, the plan may be amended for other reasons, but eventually at the end of this process, the board is required to adopt a tentative plan and transmit the plan to each municipal governing body in the county for the next step in the process. So the anticipated timeline for this step is April 2021 through May 2021. And this has to do with, again, the counties have 60 days to do the tentative plan process, and the federal census results needed for redistricting are required to be published by the Census Bureau, I believe no later than March 31st of 2021. So that would kind of kick off that 60-day clock. Step 2 in the statutory process is creation of wards. So upon receipt of the tentative plan from the counties, each municipality has 60 days themselves then to create wards or adjust their ward lines in accordance with the supervisory redistricting plan. Municipality is required to make a good faith effort to accommodate the tentative plan for the counties, and divide into wards in a way that permits the creation of a final supervisory district plan, particularly with respect to the equal population requirements. Once the municipalities create the wards, the municipal clerk for each municipality is required to forward the copy of the ward plan to the county within 5 days after it's been enacted or adopted by ordinance or resolution. And again, with that 60-day time period occurring after the county's first step in the process of adopting the tentative plan, that would be expected to occur in June and July of 2021. So then step 3 in the statutory process is the adoption of the final supervisory plan. Again, in this situation, the county is again required to hold another public hearing, and then also assign numbers to each district. Obviously, the plan might have to be modified based on the wards for each municipality or other factors. And again, the statutes here also emphasize that contiguity requirement again, the requirement that each district must be fully connected within itself. Once the final plan is adopted by the county board chair must file a certified copy of the plan with the Secretary of State. Then that plan is in effect until it's superseded by another plan enacted under 5910. Generally, that's only going to be, again, after the next federal census, though there are some opportunities within the decade to change or to redistrict again based on reducing the size of the county board. That's not typical, but it is possible. And again, counties have 60 days to do this once they receive every municipal ward plan in the county. So once they get that last municipal ward plan, that 60 days kicks off, likely, unless everyone is way ahead of deadlines, that this process will occur in August and September of 2021. So now we're going to do a little bit of a deeper dive into the creation of wards. This step 2 in the statutory process that we talked about. Again, not something that the county is in the middle of and really taking a lot of action on themselves, but it's important to understand this process because it will aid in adopting that tentative plan or drawing those initial lines with the understanding of how the ward process works and what municipalities are required to do. Kind of again tying back into the theme of early cooperation and information sharing with municipalities to make this process more efficient. So wards are every town, village, and city subdivides into wards to facilitate election administration and establish districts for aldermen, supervisors, legislative districts, congressional districts, to facilitate creating those districts that are substantially equal in population. So it all really starts at a base level with the municipalities dividing themselves into wards, and that allows each governmental unit up from their counties to this all the way up to the state to create their districts that are in substantially equal population. So again, every city, village, and town is required to divide it into wards, unless there's a limited exception. Counties with only one town, or the only town in the county, is not required to divide into wards, though they may. Wards are created for cities, the common council or the village or town board. And this is important. The boundaries and the number assigned each ward are intended to remain as permanent as possible. This obviously can change if there's significant shifts in population between each census, or even within the county, if it requires totally revamping the county supervisory districts, it could have an effect of really putting municipalities in this position where they have to adjust their wards, maybe even if their own population hasn't really changed that much. So wards do not have to be exactly equal in population, but Wisconsin statutes prescribe a range for municipalities of different populations. So just running down the list, I mean, as an example, cities with a population of at least 150,000, wards must be at least 1,000 inhabitants, but not more than 4,000. Cities with a population of at least 39,000, but less than 150,000, not less than 800 or more than 3,200, and so on. As you can see, as municipalities get smaller, that range becomes lower as well. Again, as mentioned before, this is accomplished by the governing body of the municipality, and the wards are created by either ordinance or resolution, and are all required to have unique whole numbers, and are also required to have designated polling places for the facilitation of elections. So going back to that concept of permanency, if possible, once wards are established, the boundaries are required to remain unchanged until either the next census indicates that the population of a given ward is above or below the applicable population range, or ward boundaries are required to be changed to permit the creation of a supervisory or aldermanic district plan of substantially equal population, or a few other reasons, such as enhancing participation of a racial or language minority group in the political process and their ability to elect representatives of their choice. So, for example, if the new census comes out and in a city of greater than 150,000 people, a ward's new population based on the new census is above that 4,000 person threshold, the municipality the city in that case would be required to revise its ward plan. So in that case, the ward would need to be divided into 2 or more wards that fit within that range. And if that's not possible, more wards may need to be combined and divided in order to meet the range requirements. Same thing if ward drops below the bottom limit of the range, it either needs to be combined with another ward, or if combining with another ward would put it over the maximum number of people in the range. For example, if you had ended up with a total of 6,000 inhabitants in the ward because of combining, then you'd have to combine the wards and divide them into 2 other wards. Again, so that those population range requirements are met, and that's all statutory based. Also, in the ward process, every municipality is required to make a good faith effort to accommodate the county's tentative plan. Doesn't mean that they are required to exactly accommodate the plan, but if possible, they are supposed to make a good faith effort to comply with that plan if possible. if a municipality is unable to accommodate the tentative plan drafted by and approved by the county, the municipality still has to follow certain requirements so that when it divides itself into wards, the county is still able to create supervisory districts that are substantially equal in population in accordance with the population requirements of the tentative plan. So again, while not required to necessarily follow the county's tentative plan to a T, they have to at least make it possible to create the appropriate number of supervisory districts. What happens if the county or the municipality doesn't divide itself into wards, or doesn't divide itself into wards that allow for the creation of supervisory districts? If a municipality doesn't follow the statutory process or doesn't divide itself into wards, either the county or any elector of the municipality may petition the circuit court and submit its own proposed ward division plan for the municipality. In the case that a court finds that the existing division does not comply with statutory requirements, the court will review the submitted plan, and after a reasonable notice to the municipality, the court may adopt that plan and the new ward plan submitted by the petitioner and put that in place instead. Obviously, this is not an ideal situation, and again, why both statute and good practice is to communicate throughout this process from the beginning, make sure everyone's on the same page and able to efficiently work together on this. So it's kind of a lot of information. And again, that process is very technical. It's statutory based. And it may seem like, oh, it's just step 1, step 2, step 3. But a lot of the concepts that are addressed in there, such as substantially equal in population and other voting issues, there's a lot of legal issues involved with those, some more pertinent to the county redistricting process than others. But so particularly important is the substantially equal population requirement. So we're going to go through some of those issues next, and kind of go through an example of how we figure out if we're in compliance with the substantially equal population requirement. So that requirement ties back to the one person, one vote requirement that arises under the Equal Protection Clause of the US Constitution. So that requires that members of a local elected body be drawn from districts of substantially equal population. And importantly, it's substantially equal population, not exactly equal population. So there is some leeway there, but how do we know what's constitutional? So some statistical methods that are used to determine if population deviations between districts are constitutional are these 3 concepts of ideal district size, and then relative deviation from the ideal district size, and then the overall range. So the overall range is, what we're working towards with these measures, and is kind of the main metric that's used to determine what is constitutional. So walking through what these mean and an example. So ideal district size is so this is when you take the total population, in this case of the county, and divide it by the number of seats. Pretty simple. That would be, in best case scenario, if you can make every district that number of people, they'd all be equal, and that's the ideal that we're striving for. The deviation from this is calculated as either a positive or negative deviation. So by way of example, we'll say the 2010 census reveals that ABC County has a total of 100,000 people with 10 supervisors. So the ideal district size would be, take 100,000 people divided by 10 supervisory districts. So 10,000 people per district is the quote unquote ideal district size. So obviously, as we've said, exact population matching is not required. So there's obviously going to be some deviations from that. So the next step in the process is to calculate, well, what is the deviation of each district? And that's used to determine whether the 10% rule is met. And we'll discuss that in a minute here. So relative deviation then is calculated by dividing the population deviation from the ideal population and expressing that as a percentage. So continuing with our example, if there's a 500 person deviation from the ideal population of 10,000 people per district in ABC County, the relative deviation would be 500 divided by 10,000, the ideal population, and that results in 5% deviation. So then the next step in this process is to calculate the overall range. So the overall range is the range from the between the largest district in the county and the smallest district. So taking out everything in between, just what's the range between the smallest and the largest district. So continuing with our example, let's say the largest district is that 500 deviation district, and we'll say it's 10,500 people, resulting in the deviation of 5%. And then our smallest district is 9,600 people, which results in a deviation of -4% from the ideal. So then the range between the smallest and largest district here is 9% between that -4 and the +5. So this comes into play with the 10% rule that I just mentioned. So the general rule is that 10% or less deviation between the largest and smallest district is presumed to be constitutional. Obviously, there could be challenges that could overcome that, but generally presumption is it's constitutional. It would be very hard to overturn a plan that has a deviation of 10% or less. Deviations of above 10%, though, are presumed to be unconstitutional. So again, this is really kind of lays in the message that these districts need to be as close as possible. Obviously, again, some discretion, some deviation allowed, but they really need to be as close as possible to try to meet this 10% rule to avoid any potential challenges to the plan. That being said, courts have made allowances for deviations of greater than 10%. But in that case, again, because it's presumed unconstitutional in that case, the governmental body who created the plan, in this case, we'll say the county board for counties, if challenged, is required to demonstrate that there are legitimate reasons for that deviation. So it's switching the burden. So that if it's 10% or less, the burden is on any challenger. It'd be very hard for them to overcome. If it's greater than 10%, the burden is on, in this case, the county to prove that there were legitimate reasons for that deviation being greater than 10%. That being said, a deviation of 16.5% is unconstitutional. Or at least so far, courts have held that that's unconstitutional because it's so far from that 10%. So even in that case, counties or other governments cannot overcome that deviation with a showing of legitimate reasons for it being greater than that. So how does a county overcome or show or justify the reasons for going over 10% on that range. It's based on traditional redistricting concepts. This includes drawing districts that are compact and contiguous, keeping political subdivisions, so municipalities, intact in the same district if possible. Protecting incumbents is actually a legitimate reason. Preserving the core of existing districts, and also complying with the Voting Rights Act, which we will talk about more in a minute here as well. And part of the reason, well, and another important note as well is that the courts have recognized that local units of government have a bit more leeway in deviating in having a greater range than 10%, due to the fact that they often have fewer representatives than, for example, state or federal elections. And the state, obviously, there's many state assembly representatives, state senators, congressional districts, and that sort of thing. So having this smaller population and smaller number of representatives being elected lends support to local government's arguments for deviating greater than 10%. It's not a license to go out and say, well, we can go over 10%, we're fine. There still has to be legitimate reasons for that. It's just so happens that local governments are given a little bit more leeway than the state would be given. Next, we'll briefly talk about minority populations and considerations of race, and this gets into the Voting Rights Act. So here we're concerned with dilution and methods of dilution. So vote dilution as opposed to vote denial refers to the use of redistricting plans and other voting practices that unlawfully minimize or cancel out the voting strength of racial or racial groups or other minorities. So three techniques that are frequently used to dilute minority voting strength are fracturing, stacking, and packing. So fracturing refers to fragmenting concentrations of minority populations and dispersing them among other districts to ensure that all districts are majority white. Stacking refers to combining concentrations of minority population with greater concentrations of white population, again, to ensure that districts are majority white. Or packing, which refers to concentrating as many minorities as possible into as few districts as possible to minimize the number of majority-minority districts. So that's where Section 2 of the Voting Rights Act comes into play. It's intended to prevent these types of unlawful voting practices. So Section 2 of the Voting Rights Act is designed to prevent dilution of voting strength of racial and other minorities through redistricting. Section 2 provides that voting practice such as redistricting is unlawful if it results in discrimination. So it's a totality of the circumstances analysis where if minorities are provided with less opportunity than other members of the electorate to participate in the political process and to elect representatives of their choice, if that has occurred based on a totality of the circumstances, that's a Section 2 violation. So things that the court is going to look for in that totality of the circumstances analysis include block voting, history of discrimination, depressed levels of minority employment, income disparity, and lack of minorities elected to office. Important to note, though, Section 2 doesn't create a right of proportional representation. So there's not a right to have members of protected class elected in numbers equal to their proportion of the population. It's ultimately just a question of whether a group has been denied an equal opportunity to participate in the election process and an opportunity to elect candidates of their choice. Again, also important, Section 2 of the Voting Rights Act can apply to any jurisdiction in any state. So it's a consideration at every level of the redistricting process. Persons permitted to file a suit to prove a violation of Section 2 to challenge a redistricting process. So how is that claim established? The foundational case is this Thornburg versus Ingalls. It's a United States Supreme Court case. Established a three-part test that a minority group must prove in order to prove a Section 2 violation. So that test, the first step is that the group is sufficiently large and geographically compact to constitute a majority in a single member district. Step 2 is that the group is politically cohesive. And then step 3 is that in the absence of special circumstances, black voting by the white majority usually defeats the minority's preferred candidate. If all three of these conditions are present, then the presumption is that the minority district must be established. So walking through what these each part means. So requirement 1 is that in order to satisfy the first requirement, the minority must make up 50% of the district plus 1 of the voting age population. So the reason for that is that only the voting age population has the potential to elect candidates. So a simple majority of the proposed district, 50% plus 1 voter. Reason being, as the Supreme Court has noted, is that only when a geographically compact group of minority voters could form a majority in a single member district has the first Ingalls requirement been met. Obviously, if a majority cannot be formed, then there can't be a violation. Also, along with that first requirement is the compactness element noted by the court. So the proposed district must be reasonably compact and regular. It can't be an odd shape. And I think we've all seen maps showing oddly shaped congressional districts that are squiggly lines or shaped like a U or something like that. When we're talking about a Section 2 violation, we're making sure that the proposed district is at least reasonably compact and regular, and at least is in line with other districts and looks similar to those other districts that have been drawn. There's no really scientific approach to this determining whether this compactness element has been met. Courts apply an eyeball test to make sure it looks reasonably compact and similar, again, to those other districts drawn by the governmental body. So requirement 2 is that the minority group must be politically cohesive. So this is shown by evidence that a significant number of the minority group members usually vote for the same candidates. The Supreme Court has also stated that racial bloc voting and political cohesion can be established if there's a consistent relationship between the race of the voter and the way in which the voter votes. So if a group traditionally votes for the same party, for example, most courts have applied a common sense rule that if a majority of minority voters vote for the same candidates a majority of the time, the minority group meets that politically cohesive requirement. And then the final third requirement of Ingalls is whether block voting is legally sufficient. So that's satisfied if the majority votes sufficiently as a block to enable it to usually defeat the minority's preferred candidate. The fact that some minority candidates may have been elected does not foreclose a Section 2 claim. What's important is where a challenge scheme generally works to dilute the minority vote, it cannot be defended on the ground that it sporadically benefits minority voters. Shaw versus Reno is another important United States Supreme Court case dealing with restrictions on considerations of race. So this has to do with strict limits placed by the court on the manner in So the Supreme Court has established a strict scrutiny test in this case. So the state or local government must demonstrate that the race-based factors were used in furtherance of a compelling state interest. For example, that'd be complying with the Voting Rights Act. That would be a compelling state interest, so then certain factors are permissible. Criteria that local government should consider: use of identifiable boundaries, using whole voting precincts, maintaining communities of interest, basing the new plan on existing precincts or districts, adopting districts of approximately equal size, drawing districts that are compact and contiguous, keeping existing representatives in their districts, and when considering race, narrowly tailor to comply with the Voting Rights Act. And the last kind of legal issue we'll talk about is gerrymandering, which everyone is probably fairly familiar with. Not something that's necessarily a huge issue for counties because county supervisors are elected independent of political, it's not a political election. But it's something that may come up and may be something that comes up, especially in these public hearings that are required, maybe brought up by residents for whatever reason, providing comments to the way districts are drawn, if they don't like the way the districts are drawn or have some issue. So gerrymandering is a process where the majority party draws the election district map with boundary lines that give itself an unfair advantage. So even though it is a majority party, it draws lines in a way that gives it even more seats. So this advantage is obtained by maximizing the number of districts with majority of voters from the majority party. Again, not a huge deal necessarily for counties, but something that everyone should be aware of in case it needs, it comes up in these public hearings or needs to be addressed at any point. So concepts of gerrymandering are very similar to the concepts we just talked about with Section 2 violations. But in this case, the terms are packing, vote dilution, and fracturing. So packing is a gerrymandered map that concentrates minority party voters into the fewest possible number of election districts. Vote dilution is when minority party voters are distributed among many districts so that their vote will not influence the election outcome in any one district. And then fracturing is where an incumbent minority is divided into multiple new districts with a majority of majority party voters. So the results that end up happening from this are weird looking maps, weird districts, kind of like I mentioned before, weird kind of squiggly districts or shaped like a U or small corridors running down roads or areas that aren't heavily populated. Generally, gerrymandering is permissible to an extent, though the U.S. Supreme Court has held that partisan gerrymandering, they're standing to bring a claim under the Equal Protection Clause of the 14th Amendment of the U.S. Constitution. So the court, in this case, in Davis versus Bandemer, is another foundational case. In gerrymandering, the court denied the claim that district lines must be drawn by allocating to each party a share of seats in proportion to what their anticipated statewide vote would be. So if the breakdown is 52-48 for voters for two different parties, let's say, in the state, the minority party is not entitled to districts that would allow to obtain 48% of the seats. But unconstitutional discrimination can occur when the electoral system is arranged in a manner that will consistently degrade a voter's or a group of voters' influence in the political process as a whole. A case that many of you may have heard of is Gilbert Whitford. That's a Wisconsin case. Where in that case, the plaintiffs alleged that they lived in districts that were unconstitutionally gerrymandered, while others claim that unconstitutionally drawn districts statewide violated their rights. So interestingly, while this concept has not been heavily addressed by the Supreme Court, so there's not a lot of overarching Supreme Court precedent or guidance on the matter, the district court in Wisconsin held that the legislative districts were unconstitutionally gerrymandered and impeded the minority party's ability to turn its votes into legislative seats. But the U.S. Supreme Court on appeal held that the plaintiffs lacked standing to bring the case. So the court did not weigh in on the merits of the case. They kind of punted it back down to the district court to determine, allow additional opportunity for fact-finding and for the plaintiffs to establish that they have suffered concrete injuries to their constitutional rights. Again, the court acknowledged that this was an unusual move, but as I mentioned, this is an area that has not been well settled by the Supreme Court, which is probably part of the reason why it was sent back down for further analysis. Probably we'll hear or have another decision or order from the district court. We would expect sometime this year, which then, depending on the outcome of that, good chance that would again be appealed to the Supreme Court. So that's an important Wisconsin case that happened recently. There's also two other recent cases from 2019 where the Supreme Court heard oral argument. Again, two partisan gerrymandering cases this time in North Carolina and Maryland. Again, these cases focus on partisan gerrymandering, which may not really affect county redistricting to a large extent, but it's kind of been a hot topic lately, and we would expect at some point that the Supreme Court provide a more substantive ruling on the matter. So it's kind of a hot button issue that could come up in these public hearings, even though not super relevant to the county process itself. So that kind of covers all the legal issues that we're going to go through today. And just kind of as a last slide here, we have a breakdown of the maximum number of county supervisors that may be allowed in the redistricting process here for your information. So again, similar to the ward breakdown, having having the population ranges. This provides population ranges where and a maximum number of supervisors that counties may have. So again, that kind of takes us through the substantive portion of our presentation here. So we can open it up to the Q&A.
Wonderful. Thank you so much, Ben. I appreciate you presenting that information. Yes, so please, if you do have a question, let us know. You can type it in again at the bottom of your screen, or if you're on the phone, press *9. So we do have a couple questions here in the Q&A section. First is, they're asking whether or not redistributing presents an opportunity to reduce the number of supervisors and increase the representation population per supervisor. If so, what might be the best way to approach that change?
Yeah, so I think that ties back into the concept that redistricting is counties start from a clean slate with every census. So using these ranges we have here, these are the maximum number of supervisors that can be for each district, and kind of every 10 years here, you're starting over. So if the county had 35 supervisors previously, it'd be permissible to change the districts in a way, again, because starting over, that you might only have 33 supervisors now.
My bad. Let me start again. So another question here is, if you have a rural county with district populations of 1,000 per district, and they have a federal prison with a population of 900, you would end up with a district that 90% could not vote. Would this give the county a reason to be beyond the 10% deviation rule?
It's an interesting question, and honestly, I don't know the exact answer off the top of my head. I believe that federal prison inmates would be counted as residents of their home county. At least that's how it's traditionally viewed for other legal purposes, but I will look into that question and provide some follow-up on that. That's a good question.
All right. Next question is there a minimum number of county board supervisors?
It's another good question. I know that there's the maximums that we have up on the screen here. I know that there's an answer to that, and I know that I've looked at it before, but I can't remember off the top of my head, and I don't have it in my notes here, so I will look that up for you.
Okay, we will get back to the person who asked that question. Next, what software will be available for creating districts?
Yeah, I'm not sure exactly if there's particular software. I know most counties, or a lot of counties, tend to use GIS data, kind of overlay that with the population, with the information they get from the Census Bureau. And I think typically a lot of counties hire consultants who are familiar with those GIS systems and are able to assist with that process. I think that's the typical way that it's done. I'm not sure that I've ever heard of any specific programs for that, but that doesn't mean that they don't exist. I just think that the typical process is to use GIS software and often to use a consultant to help draw those lines. Particularly, I think a lot of surveyors are involved.
Next question is, what are the notice requirements for the public hearings on the tentative county plan and the final supervisory district plan?
I'm not sure. I think they're at least I think they might be a class 1. I'd have to confirm on that, but typical notice requirements of other that apply to other county public hearings. I believe it's a class 1 notice though.
And I just had someone who also just weighed in on the software question. They said that LTSB, which is the Legislative Technology Services Bureau, has created a portal to assist counties in redistricting. So that is available as well. I personally do not have that information. However, that doesn't mean that we can't get it and somehow provide that information to everyone looking for it. So we will take a look for that as well and post it on our website for you all to review. That's it as far as the questions that have been posted on the Q&A portion. Is there any other questions out there?
I do not have any raised hands.
Okay, I'll just do one last call for any questions. Anybody out there have any questions? If you do have a question after we complete the program today, feel free to contact myself, Marcy Rainbolt at the Wisconsin Counties Association, or any of the government affairs staff at the association. We'd be happy to help and connect you to Ben if needed. So with that, thank you all for participating. Ben, thank you so much for providing your insight and knowledge on this issue, and we appreciate your time.
Marcy, let me just comment. Somebody did just chat. To answer everybody's question, this will be posted online along with a copy of the slides. We have recorded it, so we'll get that posted to our website.
Thank you, Anne-Marie.
Thanks, everyone.
Thanks, Ben. Bye-bye.
Bye.